We are live.
We are live. Good morning. It's Senate Judiciary Committee. It is Friday, January 15th, 2021, and we're meeting via Zoom. Many of you may be watching this on YouTube, and that's great. And the issue today is S18, which is an act relating to good time, which is a process whereby offenders are able to earn time off of their sentences through good behavior. And probably should be a better word than good time. Maybe we can
earn time.
Yeah, earn time might be better because I think that it has connotations that aren't intended and is somewhat offensive to some victims, I'm sure. So with that, I turn it over to our first witness this morning, is Sarah Robinson, who has to leave by 9:15, but I don't think we'll be I don't think we'll be 45 minutes. But Sarah, thank you for your patience and holding off. You were originally scheduled earlier in the week.
Thank you for having me. For the record, Sarah Robinson, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. Good to see you all this morning. And thanks again for the opportunity to say a few words on the Earned Good Time program and the language that you're considering today. I just wanted to as a brief bit of history, the Vermont Network, we didn't serve on the original committee which developed the legislative recommendations for the Good Time Law that was passed last year, although we certainly have been engaged in related and broader conversations about victims' rights and criminal justice reform efforts. And in almost all cases, we believe that these are complementary efforts that just require some careful balancing. And in concept, we're very supportive of earned good time. As you've heard from other witnesses, we do believe that incentives play an important role in encouraging growth and change in people who are incarcerated. We think that's a good thing, and that an earned credit time is one way to achieve this, or earned time program is one way to achieve this. But as you heard from Chris Fenno and the Attorney General earlier in this week, since the legislature passed and enacted this law last session, we've heard from victims all across the state with real concerns about the one-size-fits-all approach to the applicability of good time to individuals serving sentences for every possible crime. And we very much understand that the state's previous good time program was overly complex. It relied on the discretion of DOC staff and ultimately led to disparities and inaccuracies. So very much support the intention to move to a system that removes discretion about good time accrual and promotes a more simplified approach. But we do agree with the Attorney General's office that for certain crimes where there is a death resulting, and for the worst forms of sexual violence, that the impact on victims and surviving family members of those crimes ought to be given weight in the state's good time program. And so to this end, we support the language that you are considering today. And I wanted to also lift up a second concern that's not necessarily addressed in this language, but that's related to victim rights and notification related to earned good time. And this past last year, we testified at length in House Corrections and Institutions about the importance of a victim-centered notification process for earned good time. And you do see a requirement that the Department of Corrections notify victims at the onset of the program about the new statute. But we've heard really major concerns from victims about the plans that the Department of Corrections has for the notification process. I'm sure you can hear more about that from the Department of Corrections, but both the frequency and the mode of the notifications that the department plans to use. And our current understanding is that the notification plans would require an opting in to all notifications related to this, or an opting out of all notifications on behalf of victims. And we would love to see some additional options available to victims in terms of how they hear about earned time accrual and when they hear about earned time accrual. And on victim notification, I wanted to address something that Senator Baruth raised in the discussion earlier this week about moving forward, victims being notified about the potential impact of earned time on sentences. And we are concerned that there is currently no standard process in place for prosecutors communicating the impact of earned good time to victims when potentially seeking their input on plea agreements or informing them of the status of sentencing conversations. And there's no required notification to victims about the potential impact at the sentencing phase. And we do feel that victims deserve the right to be informed at this stage of the process about the potential impact of good time on a sentence, so they can be prepared really for an accurate length of incarceration. Their expectations can match what is possible. And when sentences are finalized, it often provides this sense of closure for a given period of time for victims to heal. So we would ask that the committee consider including language in the proposed bill to ensure that this notification does take place around sentencing. This is also an important moment for victims because that's the place where they're able to offer a victim impact statement. So we feel like that would be helpful language to include. And with that, I am happy to take any questions that you might have.
I guess I had two questions, and one is the way the language is structured. Those who would be sentenced after the effective date of the bill, I believe it's sentenced, not convicted, but sentenced, would have an opportunity to petition for receiving earned good time. And wouldn't that involve the victim as well? We just talked about the victim notification. I'm sure the victim's concerns would be taken into account if the offender petitioned to receive good time. If they didn't petition under the way this is drafted, they'd have the normal input that they have at a trial, but the person wouldn't be eligible for good time. So I'm a little, if you put your language in, I'm not sure where it goes. Maybe it's part of the petition if they do petition.
Yeah, I think at a minimum, I think ensuring that victims have input in that petition process would satisfy that.
Because if they didn't petition, they wouldn't be eligible for the good time. So good time. The second question pertains to that same. We have a subset of people who were convicted prior to January 1, 2021, who are now eligible to earn good time moving forward. They're not getting it retroactively, and I'm not sure that message has gotten out to many individuals. That it's not retroactive. That was one of the discussions we had last year when we passed the bill. So I hope that there's not confusion about that part of it. That at best they would only be receiving it moving forward if this bill doesn't pass.
I think there is good understanding about that among victims. I think initially there were some questions, but I think at least the victims we've heard from fully understand that the good time accrual only began after the law came into effect. What I will say is that it still has the potential, obviously, to change sentences that, over time. And so I think for some victims, it felt like they had a promise around a certain length of sentence, and that that promise had been changed, and there was concern about that.
But the other more question, I've divided this into two separate groups. One is those that are sentenced after the effective date of this bill, And whether because everybody would know what the good time is, it would be back the way it was years ago when everybody was eligible for it. And should we just have it effective for the smaller group that had not been earning good time and are eligible starting this January 1st, and just focus on that group. Since everybody would know what the rules of the game are in any new
Moving
sense.
forward.
Moving forward.
I will defer to the Attorney General's office and attorneys on that, and whether that poses any legal concerns, but it would certainly simplify the program and the expectations for victims, I do believe.
Okay, other questions for Sarah? Sarah, thank you so much.
No, thanks for having me.
Our next witness is Matthew Valerio, Defender General. Morning, Matt.
Good morning. Thank you for having me. As I had expressed on other occasions regarding the potential for this bill, it's obviously some backtracking from what the work that had been done with Justice Reinvestment 2 and the proposal that was brought originally by the Department of Corrections to reinstitute good time after a decade of not having it, and the pressures that put on other methods of release from the Department of Corrections, the corrections budget, and the obviously the inmates and other people involved in the system. We all know why I think good time is something that has been used around the country. There are multiple reasons, but just briefly, of course, it's in part a way of modifying behavior with a positive reinforcement. That if you do what you're supposed to do when you're in a facility, you're going to get out sooner. It is also a fiscal tool to aid the state in reducing the cost of the prison population. And it also, in the long term, seems to have good rehabilitative results for the individuals who are going through the system. I've not seen a study that says that good time has a negative impact on rehabilitation. The interesting thing that this bill does is selects out a few crimes that all end up with life in prison at the end of the sentence, except for one. And makes them a disqualifying crime. For purposes of good time, absent a petition to the court, and then the court has to make a finding whether or not at that time it would serve the interests of justice for that individual's participation in good time for that to occur, and that it wouldn't unreasonably affect public safety. The thing that I find about that is that it's the wrong time to make that determination. What you end up seeing one way or the other is clearly a change in the way people think and act and approach their lives once they have been incarcerated. The determination at the beginning of the case, really at the beginning of their sentence case, of whether or not somebody is going to be an unreasonable risk to public safety, is probably not the right time to do that, because you don't know what a person is going to be 20 years down the road with some of these life in prison sentences. I'm mindful of an individual who I represented in a murder case in the early 90s, and he was 18 years old at the time. um, and went through the court process, and ultimately he was not convicted. But if you saw that individual when he was 18 years old and what his life was like, whether he was sentenced or not, you would deem him an unreasonable risk to public safety. He ended up joining the Marine Corps. He was in for a number of years. He got out. He started a business. He now is living on Long Island and owns a private investigation firm and is 5 times richer than I am. The bottom line is that when a lot of these folks come into the system, and we are dealing with a lot of young people, it's very difficult to make the determination about the reasonability of somebody's effect on public safety at the time they're sentenced. I'm concerned that, and I also want to talk about a little bit about some of these individual crimes that are listed as disqualifying offenses. But it seems to me whenever you have a life sentence type case, effectively a judge is making a good time determination at the beginning of the sentence by virtue of the length of the minimum sentence. The judge is accounting for the effect on public safety and the just interests of whether an individual, how long basically they're supposed to spend in jail before they have an opportunity to get out. That's what minimum sentences are for. What good time is supposed to do is give somebody an incentive to reduce that amount. So if a judge in any of these life in prison cases feels that that person needs to spend 30 years in jail, and good time might reduce that to 25 or 20 years, depending upon what the case may be, they're going to impose a 35-year sentence. And we have seen this time and time again when over the years, at least, when judges are making accommodations for good time and when release dates might be. I have a question about, so to me, the factor that the court is considering in whether or not somebody would take part in good time is something that they take into account when they are deciding what the minimum sentence is to begin with. I do have questions about why manslaughter in violation of 2304 Title 13 is on this list. That's a 15-year felony with a 1-year mandatory minimum that can be suspended. Burglaries have higher sentences than manslaughter, and I understand somebody lost their life as part of this, but it's a negligent death, which to me stands out starkly in this in the rest of the list. It doesn't have a life sentence attached to it, and it's relative to the spectrum of crimes that's out there to include on a list like this. It is one that stands out as not consistent with any of the thinking that went into the other ones. And so I would suggest that you probably should take that one if you're going to go forward if this is going to pass. I would take manslaughter off the list. I also have concerns about lewd and lascivious conduct with a child. Vermont has, in my estimation, in my looking at this over a long period of years, an area of law in its sexual assault statutes that is not fair and not consistent with reality. And I'm talking about where you have minors engaged in activity that gives rise to criminal liability under the lewd and lascivious conduct statute with a child, where you might have a 16-year-old having relations of some variety with a 14-year-old or a 17-year-old with a 14-year-old. As you know, we have that provision where there's basically a 3-year window, but the negotiation, I was there when it occurred, in the early 2000s. There was as it often is in the legislature, a negotiated age limit
between the House and the Senate.
Right. And the line was drawn at the age of 15, but that doesn't take into account the reality of kids being involved with each other when they're 16 and 14, 16 and 13 and 15 and 13, and basically kids who go to school together have the potential to get involved, and particularly with lewd and lascivious conduct, as opposed to sexual assault on a minor. But the same issue goes for sexual assault on a minor, as far as I'm concerned. And until we address that, I would not want to disqualify kids who are engaged in that kind of activity, which I think we can all agree occurs somewhat regularly, from good time. I mean, it's another one that sort of stands out to me as being inappropriate for this list, and it's one that in of all of these, we have a general thing where we tend to have a lot of youth in the system, but this is one particularly where the impact on youth would be inappropriate and disproportionate. Clearly, what you're doing when you're 16, 17, 18 years old is not what you're going to be doing if you end up spending, 2 or 3 years in jail. To me, it rings as an inappropriate crime to put on the list. Similarly, with sexual assault, while that sexual assault includes a lot of different activity, but I'm concerned about the age gap regarding minors and how that impacts individuals. One of the other things you're going to want to do with sexual assault cases, to be honest, and this is getting out of the whole youthful offender arena, and I don't mean that in the big youthful offender. I mean that in just young people engaged in activity that's illegal of a sexual nature. But you want to have people to be encouraged to participate in programming, particularly if they're sex offenders. Treated sex offenders have relative to the total recidivism rate that we have a very low recidivism rate. Untreated sex offenders, it's quite the opposite. And to take away an incentive is, I think, inappropriate. Now, I understand that the counter basically is that a judge can override that by virtue of a hearing. And I get back to the issue of this is what judges do when they set minimum sentences. I understand, obviously, with that it may be appropriate for cases like first-degree murder, aggravated sexual assault, aggravated murder, and the like. But this seems to dip kind of deep into the into the kind of serious crime spectrum. Even arson causing death is for the most part unless it's intentional, usually a negligent act situation. The arson might be intentional, but the cause of death may not be, and that's again, one of those things that it's very difficult to just stick it on a list and say we're carving these out. I would also note from a logistical standpoint, nobody likes to hear this part. This is going to, depending upon how it is dealt with by the Department of Corrections, if it were passed, going to end up in a bunch of litigation involving who gets what and how and when. Because the statute went into effect on January 1st, we're 15 days into good time for everybody. Or I guess that we probably excluded aggravated murder. I think something was excluded the first time around.
I think we excluded those with a life sentence without
anything with life without parole as
was excluded.
But there's going to be a class of people who are previously sentenced who are entitled to good time post January 1. There's going to be a class of people who are going to be sentenced post January 1. And all of those have vested rights as of the 1st of January. And then there's going to be this other group that comes if this gets passed that will have other types of rights. And I'm not even sure how those will work particularly. The question is, there are going to be issues of retroactivity and ex post facto application. And we're going to have to deal with all of that. The last time we sort of trued up the system, basically everybody who might be entitled to good time just got their good time. And it was an easy way to deal with it. But at that point, good time was going away completely. This time, we will have created 3 different classes of good time participants. And so I unfortunately see work that really the Prisoners' Rights Office, which they'll be doing, and our appellate division going to something we'd rather not be doing, to be honest. We'd rather not be kind of litigating that nuance, but it is what we do.
Yeah, no, I understand. And
so, I don't see that what is in place currently is an egregious violation of anybody's rights. I don't think that the victims' groups were excluded from participation in the process that went into this. And I was in the House as the testimony came in from all sides. This was not a major issue until the rule was promulgated by the department, and some victims who didn't feel that they had a voice in the process made their voice known. I had an individual from the Prisoners' Rights Office present at the public hearing, or one of the public hearings, and it was her, and there were 20 victims folks who had showed up and acted like it was the first time they'd heard of it. And I understand that it's easy to miss things if you're not knee deep in it from the beginning, but this was not done under the radar. And I think trying to unravel it to identify a small group of crimes that I think are already addressed through the sentencing process, where, by the way, the victims and victims advocates have the right at sentencing to comment on the appropriateness of the minimum and maximum of the sentence, and whether it's suspended or not, and the like. That's where the appropriate impact or appropriate input is. How somebody reacts to their incarceration and what position they are in, in participating in their programming, in not causing problems and serving their time. That is not something that is known at the time of sentencing, and it is appropriately left to an administrative good time system like is done in almost every other state in the nation.
I appreciate the testimony, Matt. And I don't know if there are other questions for Matt from anybody on the committee. Are there any questions? Yes, Senator Bruce.
This is not a question, but I just wanted to say that I think Matt makes a very good point about the hearing and the petition. If that's occurring at the same time as the sentencing, if I'm a judge, it doesn't seem like I have very much to go on. I have what seems to be the legislature's intent that good time not be given to this person. And then I have victims there saying, don't give it to this person. I don't know how successful those hearings would be at that point. So if the bill does go forward, maybe that's something we should think about, is selecting a time later on down the road to have those hearings.
Well, I don't know. Senator White, do you have a question or comment?
No, I was just going to say that I agree with Senator Baruth. I think that it doesn't make much sense to do it at the time of sentencing.
Well, I think that, as I recall, all this discussion about good time being retroactive was the major discussion at the time that we were doing the bill. And are there any other? Senator White, and I've got a quiet.
Marley is
So
out of control.
I guess I misunderstood what you said there, Senator Sears, and I'm sorry that just because it happens later on doesn't mean it's necessarily retroactive. I mean,
Right.
I'm not sure that they're connected in any way. The hearing could be, unless I completely misunderstand this, the hearing could be later, but still not be retroactive, but could be going forward. And or it
Dick,
could.
you're muted, Dick.
Senator White, I was paying attention to Marley. I was talking about the process we used to draft the bill the last time. When we dealt with the bill, we heard, I believe, Sarah's correct, she wasn't there, but I believe that we heard from Chris Fenno and others, and we did not hear objection. That's what I was talking about. I understand. I'm hearing several concerns about the way the draft is currently in front of us, and that's not what I wasn't talking about that.
And to be clear, I'm not asking that there be a hearing down the road. To me, the application of good time, whether somebody gets it or not, is the application. That's the decision that the department is making as to whether or not an individual is doing the right thing. What is really obvious here is that some folks think that there's not enough punishment relative to these crimes, and that as a result they should be excluded from good time. But to accommodate folks, there's this out with this hearing at the beginning. I don't think that it should be, it's not the appropriate time, in my view, for that type of hearing. And the good time system itself is the process to determine whether or not somebody is amenable to treatment and the like, and is would not unreasonably affect public safety down the road, as is referrals to for parole or for furlough.
Well, assuming for a minute we pass this law with some changes, and we only did it for those folks who were sentenced prior to the passage of this law. With that, and so in the future, I mean, the judge would know, everybody would know what the person was eligible for in good time. It'd be part of the sentencing process.
Oh, so the issue is here for these types of crimes or some group of them. The concern is the folks who prior to January 1st had already been sentenced.
Yep.
Well, I will say that clears up some of the concerns for sure. You know, I'm not gonna say that individual inmates are not going to want to litigate it, and that would mean we'd have to pursue that for them.
Understood.
But it clearly does sort of give the folks who were involved in whatever the prior plea agreement was what they expected.
Yep. Senator White.
I'm showing my ignorance here, but just because you're eligible for good time, and you may even isn't there some kind of a system set up in DOC that then decides whether you're actually going to get it or not? Just like,
Of course,
you said, parole. I mean,
Yeah.
you're eligible.
I think the commissioner is scheduled shortly after.
So I guess if that's the case, why would we prohibit anybody from being eligible?
I think that the issue that I've heard loud and clear from several victims of some horrific crimes, some of the most horrific crimes that have been committed in this state, is that this is going against what they had understood the sentence to be for that individual by providing them with extra benefit. So you're essentially, just for the sake of argument, let's say you're taking 5 years off of a sentence of someone who committed a horrific crime and the victims had agreed to that sentence, and now you're taking off 5 years. That's what I've heard as the complaint. What I was suggesting was that down the road, after this bill is effective, there would be the knowledge that the person was eligible for good time during the sentencing process. And the judge, if the judge wanted to, or the state could argue for a longer sentence than they might otherwise, because they would know, everybody would know what the rules of the game are. What we did was change the rules of the game midstream for those that have already been sentenced.
I think one important thing to note, though, is that just because you are eligible for release doesn't mean that they're going to release you, or that they have to release you when as a result of the good time.
I'm trying to make this, Matt, I'm trying to suggest that there are two separate categories here. One are people who've already been sentenced under a system that did not include good time.
Right.
And those who were sentenced in a system that did provide good time.
I understand.
Could I just add one more concern here and hopefully I'm not really misunderstanding this, but when somebody is sentenced and the victim is part of that hearing, that sentencing hearing, and then say they're sentenced to 15 years, but they're eligible for parole at a certain time, couldn't that also be seen as a violation of the, if they're given parole, couldn't that also be seen as a violation of the kind of agreement that was made with the victim? And when there is a parole hearing, I believe that victims appear. And if they're, and so I think that it's kind of the same system, but I may be wrong.
I wanted to, Matt, if you want to respond to that, I guess it was to you.
It's just another way for us to get people back out into society, and we use very similar criteria, you know, with a board, and you know, I'm sure that victims are not always happy with the decisions the parole boards make, and DOC isn't at times either, but it's just one of the other tools that we have to get people out of facilities.
Well, before I turn to Jim Baker, who has to leave, I just want to mention that that's part of what justice reinvestment was, is limiting the number of furlough options, because the furlough was without victim input, as I understand it. So people would be out in the community without that input. The parole provides that. Jim, if I know you have to leave right away, and we'll jump to you for any comments and then go to Flacco Schilling.
Yes, Senator. Listen, I did email
Interim
Peggy.
Commissioner, interim Commissioner.
Interim Commissioner, Senator. Thank you for that. Clarify the record. Senator, I did just email Peggy to let her know that I was going to stay on. I canceled my other commitment. So if you've got other orders that you wanted to follow, I can wait or I can go now. It's your call, sir.
No, why don't you go ahead right now, Jim, and then we'll go to Flacco and John Campbell and Lucy.
For the record, I am Interim Commissioner Jim Baker, Commissioner of Corrections. Look, I want to say clearly that corrections, our position is that we have supported justice reinvestment too. We support good time. You know, the one thing that I get concerned about as I listen to this conversation and other conversations is that somehow this always ends up being corrections is good time program. And it's an unfair burden to put on corrections. I mean, this is the justice system good time program. And some of the feedback we got from victims when we put the rule out was all over the charts. And, you know, this work came out of justice reinvestment too. And, you know, we all supported it. And then, you know, there was a realization about the victims that we've talked about before in corrections. And as I continue to hear the dialogue about the rule notification and the use of vans to do that, you know, we took criticism for that, and I understand it. But we have 15,000 victims in vans. And ironically, some of the victims who were victims of record didn't want to be notified about the rule change. And we actually had a situation with one of the individuals who became very hostile towards staff. So the point I'm trying to make is that whatever we decide to do, the more complicated this becomes, the more difficult it is for us to implement it, following the directions of the legislature. And creating more than one system for us to manage victims creates a situation with 4 staff members who deal with 15,000 victims. The more complicated we make it, the more chance that we're going to make errors in that process. So my position as the commissioner is that, you know, I understand what happened here, and I understand that people are weighing in back and forth about victims and how we ended up in this conversation now, looking to try to modify the work that came out of reinvestment too. But all I'm urging is whatever we decide to do, make it as clear as we possibly can, because you know, the Defender General and I agree on quite a bit. And one of the things I'll agree on him today with is that I don't need more litigation in corrections. We get litigated to death in corrections. You know, as I've said, I've been the commissioner for a little over a year. I think I'm named now in 120 lawsuits. So we get litigated to death. So we as an organization have a high level of empathy for victims. We want to work with victims, but we don't want to be seen as the only person in the system holding the bad news when it comes to victims. So I'm urging that whatever we do, upfront victims understand at the day of sentencing exactly what good time means. That should not be corrections' obligation to explain to victims at that point in time. That should be the judge, the prosecutor, defense attorney. People understand exactly what it is, and then we manage that system. So as far as the processes inside, I do have Dal Crook and Monica Weber with me today. They know this system much better than I do. I'm just trying to make sure we're clear where correction stands on this. And we'll do whatever we're directed to do by the legislature. But remember, the more complication that goes into it, the more difficult it is for us to manage it. So that's my message, Senator.
Thank you. That was part of the problem why we discontinued good time, because it was so complex.
And look, you're always, Senator, you're always going to have the situation where, and I agree with the Defender General on this, you're not always going to make people happy. But I heard, the one call that I took that we both got emailed on. Those victims matter. And I know you're trying to all work through this system, but I just don't want to be in the position where it becomes complicated. And we're the ones that is seen as this is corrections, is good time program.
Right.
That's the message I want to deliver.
Loud and clear. Thank you, Commissioner. Questions for Commissioner Baker? Interim Commissioner Baker. Senator Baruth.
Commissioner, thank you for what you just said. I'm just wondering if we could go back to the basic management tool idea. That's what I find myself coming back to. I remember when we were working on this, and the idea was that this was helpful inside the institution. It was perceived as a positive tool, regardless of who it was being used with. Is that still your sense?
It is, Senator. And I think, again, I haven't read the studies, but I think my staff tells me that most of the work that's out there academically on good time indicates that it is a good tool. And I do think it's a good incentive for folks. The vast majority of the people that we have incarcerated follow the rules, do what they're supposed to do to work on their issues. But we have folks in the system that don't do that. So I think good time also offers the opportunity for incentive, especially when caseworkers are working with them to move them towards transition back to the community. I think it does give us a tool to do that. With that said, I fully understand what I heard from victims about what that means when they agree to a plea agreement and then all of a sudden find out there's a significant amount of time shaved off that sentence, if that makes sense.
Mm-hmm. Thank you.
You're welcome, sir.
Thank you, Commissioner. All right, why don't we jump to Flacco Schilling from the American Civil Liberties Union.
Good morning.
I guess you've been very busy lately.
There's been quite a lot going on, as with many other folks on this call. So I know we're all doing a lot of good and hard work. So thank you for allowing me to testify this morning. My name is Falco Schilling. I'm the Advocacy Director for the ACLU of Vermont. And I want to come and speak before you today to oppose S18 for many of the reasons that folks have already heard so far. I'm going to echo many of the things that the commissioner actually just said. So we also are big supporters of Justice Reinvestment 2. This was one of the top recommendations from the Justice Reinvestment 2 working group. I think it's recommendation 1C. And when we heard from the folks from the Justice Center, the implementation of good time was one of the most effective tools we had at reducing our prison population. So this is something that when you look at those recommendations and the recommendations that have come out in reports both from 2019 and 2018 show that good time is a positive management tool for inside facilities. And we also believe that we should be incentivizing good behavior for everyone who is incarcerated by the Department of Corrections. And that also applies to people who have committed some of the most serious crimes. That we want to have those incentives for good behavior, and we also want to have those program management tools available. So one of the discussions that has come up in both this testimony and the testimony previously is the idea of whether or not this credit should be applied to people who were previously incarcerated before this change went into effect. And this is something that's been talked about at length, both through the committee's process last year, and also there's a full report that was put together prior to last session. And this was a report put together by DOC, the Center for Crime Victim Services, the Judiciary, sheriffs and state's attorneys, the Attorney General, and Defender General. And the consensus recommendation from that report is that good time should be applied to everyone who is currently incarcerated and moving forward. They give a number of reasons for this in this report. If you look at, so the report was delivered on December 15th of 2019. The recommendations revolve around program impact, and I'm going to read quickly from that report, if I may. So it says,
before you, if it's possible for Peggy to get a copy of that report and post it on the committee webpage, that would be helpful.
Yep, happy to send that over. And this was a report that was discussed, I know, a great deal in-house correction.
Yeah, I got the copy of the report, but it's sitting in my Montpelier file cabinet.
Yes, and it's, I'm sure, buried somewhere on the legislative website, and happy to help resurface that. But what the report basically says, increased participation will have a greater impact on morale and behavior. If many people are left ineligible for the program, the effect on the facility environment is diminished. It will also create disparity and confusion among the incarcerated population. So one of the main reasons to have this apply to everyone is the impact within the facilities. And the others that is noted in this report is the administrative impact, which in the report says, including previously sentenced inmates, eliminates the potential for mistake, delay in processing paperwork, and allows for clear communication as to who is eligible to receive good time and awards. The DOC sentence computation unit is responsible for its activity. Any additional burden on requirements to track the various populations would lead to uncertainty and complexity. And this is really important because as we were having this conversation last year around good time, one of the things that was raised over and over again was that increased complexity in the system that existed before was one of the things that brought that system down. That level of complexity made it difficult to administer, generated lawsuits, and was one of the reasons that it was revoked, I guess, in the early 2000s. So that's something that we want to raise, this discussion of who should be included. Everyone who is currently incarcerated should be included in this program, and we oppose carve-outs to that program. Also, just want to note that there's broad public support for reducing sentence lengths in a poll we did last year with Lake Research. 70% of Vermonters supported reducing sentence lengths for people who are incarcerated here in Vermont. And also, I'd just like to bring up the fact that making this change at this time is definitely going to be putting more of a burden on the Department of Corrections. Within the last year, we have asked them to do not just an emergency rulemaking, but a full rulemaking on this program. And this would be asking them to do a third rulemaking, possibly within the span of 1 year. And it's not like there's been new facts brought to light about this program and how it might impact people. These were discussions that were envisioned through the process last year. So in short, I'm happy to have the opportunity to come forward today and say we oppose this legislation. We'd like to see the law stay as it currently is. And this is one time when we're basically asking you to do nothing. So that is my testimony for today, and I'm happy to answer any questions.
Thank you. Questions, I think, pretty clear from me, my perspective. Any thoughts on the discussion about those that are currently sentenced who are in some of the most heinous crimes in the state, and they made plea bargains to avoid life without parole since, and that really is one of the groups we're talking about. There are, and I'm curious if there's any comment on that small group.
So we think this program should be applied uniformly throughout the system. Almost 99% of all criminal cases within the state of Vermont are resolved through plea deals. So that's not unique to people who have committed these crimes. And we have to understand that this is being applied to everyone who's had a plea deal, and there are victims of many of those crimes as well. But also we want to look at our criminal justice system and say, we need to be providing these incentives, especially for the people who've committed some of the most serious and heinous crimes, because almost all of them are going to be re-entering their communities. And it's in the best interest of all of us to provide those supports and those incentives, as well as the program management tools and the facilities to help make them safer for the people who live and work there.
Senator White.
Thank you. So Falco, thank you. My question, I guess, is that just because someone is eligible for earned time, just as they're eligible for parole, doesn't necessarily mean they're going to be awarded it. I mean, they may be am I right about that or am I wrong?
You are correct about that just because someone is eligible for good time does not mean that they'll necessarily earn that time, or that they'll be released any earlier once they reach their minimum sentence based on a number of other factors.
Okay, thank you.
And I'm sure Monica, I saw Monica chime in or come up on the screen. I'm sure she could correct me if I said anything incorrect.
Monica, did you want to comment?
Good morning, everyone. It's Monica Weber. I'm the Administrative Services Director at the Department of Corrections. And I know, Senator White, you've asked that question a few times. And Falco, yes, you were very accurate. The awarding of good time, again, relies on the offender's behavior. If they're not adjudicated of a major disciplinary action, they will receive the good time. So there is that trigger. And as you've all mentioned, once someone reaches their minimum release date, it is not an automatic release. There are lots and lots of factors that come into play there. Certainly, if you have more questions about that, Dale can answer all of them. He's sort of the expert in that area. So we just wanted to let you know that we're here to give you that information if you need it.
I think I am going to hopefully call on Dale at some point in the near future to maybe this morning or later. But the basic question is us better understanding the process and how earned good time would affect the person. And I'm going to just try to frame the question I think the committee is asking is, how does earned good time impact the actual date of release off of the minimum? So person earns certain, that's what I think that we need to better understand, why that person wouldn't be necessarily released just because they took, whatever a year's worth of good time accumulated would mean off the sentence. Looking at that for an example, it doesn't necessarily mean they're going to get out. And I really need to understand how good time impacts the furlough system moving forward. Because we had a confusing system of letting people out on furlough without any victim input, as I understand it. And then they're out on furlough, but they're not on parole, they're still sentenced. So it was a different category. Part of what we tried to replace with, if I'm not mistaken, with good time was to eliminate many of the furlough statuses.
Yes, there were.
So that has to be taken into consideration. I know in one particular case that we're all familiar with, where the guy escaped on furlough, the families of the victim who was murdered in the Bennington area contacted me, outraged that he could continually get out on furlough. There was no parole process. So those are the questions that I have when we get back to you.
Do you want
Sorry, I was just going to say quickly, one other thing that I'd like to note is in all the changes that were made in Justice Reinvestment 2, there was the institution of a presumptive parole program, but anyone who was convicted of the crimes considered in this bill would not be eligible for presumptive parole. So that is not anything that's interacting with what we're talking about here. They would go through the normal process. None of those changes would actually apply to these people.
Senator Benning, and I jumped ahead of us, and I apologize to Dale and Monica for doing that.
No, but you did bring up a reason for me to ask this question now. One of the desires of this legislation is to empower corrections with a management tool. And it makes perfect sense to me, which is why I'm supporting the bill. But I'm curious to know from all of you, and Commissioner Baker especially, why shouldn't the same process be available for someone on probation? It seems to me there is a logical connection that probationees and probationers could have another management tool that might decrease the length of time that they are on probation and clogging up filing cabinets.
Can I just ask that we hold off on the probation issue until next week, when I'm trying to schedule the Justice Center to come in and talk about the Minnesota model and why credit for probation may not be the best thing to do to accomplish the same goal. There is a full report that I'm trying to schedule for next Thursday, and Bryn is in the midst of drafting that, and Commissioner Baker and others are very familiar with what went on in Justice Reinvestment 2 working group on this issue. So I would ask if we could hold off until next week, Joe.
I'll withdraw the question.
Thank you. Blacko, any other comments or questions?
No, I think that's all I have for today, but I'll send along that study along with the polling results.
That would be much appreciated. We're asking for to get sent our files that were there from last year, since we're right now dealing with 3 bills that are connected to last year: expungement, competency to stand trial, and this good time law. So, thank you so much. Senator White.
So this may not be the time to ask this, but I was confused by what Joe said about, because he sees it as a good management tool in the facilities, that he supports this bill. So is this the time to ask him that, or should we do that later?
I think during committee discussion would be a better time to
Thanks.
figure out why we're doing what we're doing. The next witness is James Pepper from the Department of State's Attorneys. We'd originally had John Campbell, but he likes to leave the tough stuff to Pepper.
Well, thank you for having us here, or for me having me here. It's my first time in the committee this year, and it's great to see all of you back and pick up kind of right where we left off in September.
Yep.
So for the record, James Pepper from the Department of State's Attorneys and Sheriffs. Our department has served on several good time study committees over the last 2 to 3 years. The state's attorneys, many of whom have lived through the prior iteration of Earned Good Time, had certain criteria that they wanted to see accomplished in any Earned Good Time program moving forward. The first was that they wanted Earned Good Time to be an evidence-based program that can promote rehabilitation, reduce harm, and reduce recidivism. And then the second criteria was that it has to be easily administered with clear criteria for earning the time, so that victims and prosecutors understand all of the potential accrual at the time of sentencing. This, of course, is important for truth in sentencing, so that victims can establish that sense of finality that's so critical to their healing process. And prosecutors just need to know what the potential impact would be, so there's sufficient time for programming and supervision. What ultimately passed in Act 148 satisfied this criteria to our satisfaction. We heard plenty of testimony from the Council from State Governments, who was looking at the impact of Earned Good Time on other states to satisfy the kind of evidence-based harm reduction, promote rehabilitation aspects. Certainly, this program is easily administered, or at least has clear criteria. I mean, at times almost it seems like it's too easily administered. The criteria is too clear. There was an earlier bill with Earned Good Time that required offenders to kind of work through a merit-based programming system to earn good time, and that was removed. And I understand the reasons for removing it, but this certainly does make the kind of calculation of earned good time at the time of sentencing very easy to understand. So then the question, of course, has turned to whether earned good time should apply to the currently sentenced population or just move prospectively to people that will be sentenced after the implementation of the rule. And then also secondarily, whether to exempt certain categories of crimes from earning good time. Falco mentioned a report that came out that our department and Center for Crime Victim Services participated on. We grappled with that issue. We heard strong arguments both for and against applying it. I think some of the rationale for accepting the kind of, it's not retroactive, but applying it to the currently sentenced population. There's some of the arguments in support of it. Ultimately, though, we believe that because it implicates finality, that really the victims' voices and the victims' advocacy groups we were going to defer to them, and we continue to defer to them today. For us, the program makes sense, but if there are victims' concerns and the center and the network and other advocacy groups support S118, then we will support it as well. I would just mention a few things that have come up today. One is around the name of earned good time. So much of how people react to hearing about good time is dependent upon how they think about sentencing and the purposes of sentencing and rehabilitation, and being able, and really victims need to have their voices heard. And I think at least some of the sting around the announcement of earned good time in the victims' communities could have been avoided if we had the time to make those personal notifications to victims, or hold public forums and really discuss the benefits of earned good time and what it can offer. Of course, the bill wasn't passed until September of last year, and the program was required to be implemented on January 1st. And so I just don't think that we had the time to do that kind of work that could have been done.
I think that's an important point, that this bill was done during remote work, and it's an example of some of the issues that come up when we're trying to.
Absolutely. If the bill had passed, if we had a few more months, if it passed in the normal course of business, in June, we had a few more months. I think a lot of, and we had a chance to reach out to victims individually, especially with the most serious crimes. I think, the rollout could have been less painful for the victims of crimes. But again, with respect to the name specifically, I think something like earned credit accrual or something along the lines that kind of really doesn't suggest to folks that, people are, I recognize some of the arguments we've been hearing around it. With respect to the question about, is sentencing the right time for people to file petitions in order to accrue earned good time to become eligible? Essentially, this is the time where, we have the most direct conversations with state's attorneys and the victims advocates around this question of finality. And so whether it's the right time or not, it's the best time for victims to know all of the potential impacts of the earned good time program. When we're talking about the petition only for kind of a subset of the quote unquote Big 12 crimes or some of the more serious offenses. And, judges will have some sense at the time of sentencing. These issues often take, years to litigate. They're almost all eligible for hold without bail. Not all of them, but most of them are. So, if these people are being detained pre-trial, or if they've, been awaiting trial for a year or 2 years, there is some information that a judge will have at the time of sentencing to see how they've been reacting and responding to supervision and programming. So I don't have much more than that, but if there are any questions, I'd be happy to.
I have two questions. One is, maybe Eric can answer this, but my recollection of our September meetings was we were looking also at what did other states do. And I believe there's a number of states that have provisions that single out certain crimes that are not eligible for earned good time. And maybe Eric has that or you have that. I don't remember.
I believe that's right. I mean, there are a number of incentive-based programs around the country in the corrections department, corrections administrators.
Do we have a document on that, Eric?
No, I can check with, Bryn covered that issue in the fall with Justice Reinvestment.
Okay, I think somebody might have a document that shows what other states do. When you get down to specific crimes that are not part of the earned good time. And which was my way of asking about Matt's testimony regarding if we're going to do this, should C3, manslaughter in violation of 13 VSA 2304, and C5, lewd and lascivious conduct with a child in violation of 13 VSA 2602, should they be included?
If that's a question for me, I mean, I would hate to.
Yeah, it is. Yeah.
Those are, of course, incredibly serious crimes. Manslaughter, you know, there is a person who's dead. So, I mean, I wouldn't want to get into negotiating here in this forum over which crimes should or shouldn't be included. But I can tell you that those crimes that you have included are some of the most impactful for victims and victims' families. So I think that was probably the motivation for including them. And, I would, again, hope that you hear from some of the victims. And I know you've done a good job of hearing from the victims' advocacy.
Well, we're going to try to get some victims in the next week and a half or so to testify. We've got a couple who have volunteered to testify, and I'm sure we'll hear from some others. Other questions for the state's attorneys and James Pepper? Pepper, thank you very much for being here. Appreciate it.
Thank you all. Thank you.
The next witness is Dale Crook. And Dale, thank you for being here. And we're excited to hear from your position and how this will complicate your life.
Well, I mean, I think it was mentioned previous testimony. For the record, my name is Dale Crook. I'm the Director of Field Services for the Vermont Department of Corrections. This is a really difficult decision point that folks are trying to kind of weigh through. Good time works. There's tons of evidence that good time works, but there's also the rights and the needs of the victims to have their concerns heard. So, I think the commissioner brought out, our main concern is just make sure it's a straightforward system. The system that's proposed adds a few layers of complexity. One, we're looking at certain charges, and then post 2000 and now it would have to be looking at a letter or the judge's decision to earn or not earn good time. So it just adds layers. We're not arguing one way or the other, but the more layers and complexity adds, it does open us up for concerns and issues and grievances and litigation. There are multiple options that have been kind of brought around here. But we do understand the concerns of the victims and having pre-2011, 2021, excuse me, individuals earning, I can see the concerns from the victims. When you start having carve outs and determining if things do or do not get good time, if we do it pre that date or post that date when the bill becomes effective, you will have impacts on the projected savings from JRI. That's just a fact on that. not arguing one way or the other. It's just, it will cut into the savings. But good time is, you know, if you look at good time as part of the entire, as a component of the entire package of JRI, it is an incentive-based system, and the department is working on incorporating incentives into how we supervise and how we maintain our facility population. As far as furlough, I'm trying to remember some of your questions, Senator Sear.
How would we change the furlough system with some of the understanding that people who may have committed some of these listed 8, 9 crimes were eligible for furlough, which did not involve the victims, did not involve a parole process, and had been getting furlough. So now we've eliminated that opportunity. Will that further complicate any type of release for those individuals?
No, for offenders coming up to their minimum sentence, they're eligible for furlough and parole. If someone is registered in our victim notification system and they're coming up on release, they will get a notification if they're registered in the system. So all victims that are registered do get notified.
So the problem is sometimes the victim isn't registered in the VINS system.
Correct. Sometimes that's an issue, and that sometimes gets on the front end of the system, where we try to have good coordination and collaboration with the state's attorney's victim advocate, so to make sure that all the information is presented. It's just information sharing, and I think the more that we can work on that understanding, the better. As far as, sorry, sir.
So somebody who was convicted of murder in violation of 13 BSA 2301, the victims would have a voice in any parole hearing, should a parole hearing occur.
Correct.
Because they received good time, the parole hearing might come up sooner. But there's not a guarantee that they would be paroled. Is that correct?
So an individual at their minimum will be eligible for furlough or parole. So they'll have their statutory requirement for the parole review. Victims will be heard if they're called upon, and that's a parole process that can occur, and the victim will be heard. For the department to release someone on furlough, they have to meet it's the presumption that they will be released unless there's reasons for the department not to release individual. Someone not completing their required risk reduction programming, someone that poses a risk to an individual or the community. Institutional behavior that brings concern that there could be a public safety if the individual release. So we have certain criteria that we follow in order to, we call it a delay of the release. So we delay a release of someone at their minimum. If someone comes in and they don't pose a risk and they complete all their risk reduction needs and programming and they do everything they're supposed to do, and they have a residence and an approved release plan, they will be released at their minimum. And we will notify the victims of the release. That's the system is kind of geared for that. The presumption is that an offender will be released. The presumption is that the offender will be released at their minimum unless there's a reason for the department not to release them. And sometimes those reasons that we have, the Defender General may argue against, and sometimes litigations can occur from that. Did that answer your question?
Yeah, I think it does help. It does help. Other questions for Dale, Monica, or Commissioner Baker, who's still online?
Monica has her little hand up. I don't know if that means anything.
Oh, I can't see her
You
hand.
usually wave, Monica.
Oh, okay. I'll wave. I'm
Probably-
just trying to follow the rules, but I'll wave. I did want to add one thing to what Dale brought up, and in the example, Senator, that you gave, you used the crime of murder. And we also do have a process where we identify very sensitive cases, where we do a much more sort of personalized outreach in those particular cases to the victims. Our victim services specialists staff will, work with people on release plans and safety plans. So that there are some people who get a notification through VANS, and then there are another subset of people who get a little bit more engagement with the victim service specialists.
for bringing that up, Monica. As the commissioner said, we have 15,000 individuals registered in vans, but there is only direct victim services for. We assign our victim services specialist only to the more serious cases, the ones that are kind of presented in this bill, and more of the listed ones that could have a major impact.
That raises another question. This is where I think we get confused sometimes, and I'm confused about. Individual is convicted of one of the crimes that's listed on this list, and also a crime that's not on this list. Will they be receiving good time on the crime not on the list?
I think the legislature should make that clear how they want certain things like that applied. If you're going to have two different systems, for example, you have anyone before the start date of the law will not earn good time, and people post will. What happens if someone that is in one category crosses over and picks up a new offense? So
my specific question was somebody convicted of murder, but also convicted of burglary and occupied dwelling, which is not on this list. It may have been part of another crime, and they're convicted of both of them. What do we do if we have two sets of rules?
Well, what we would probably do is we'd have to make a determination, work with our legal staff, but I would indicate probably we would not award the individual good time if they have one of those disqualifying offenses.
Should we be clear in the bill?
That would be good.
That would be very helpful.
The clearer you are about what you want the department to do and how we apply good time, the better it is for everyone. So the more things not clearly defined, the department will try to interpret it in one way, and others may interpret it another way. So if it's clear in statute and language, it's easier for us to apply, and it's more easily defendable by the department.
Thank you. I didn't mean to complicate things, but it dawned on me that you have people who are convicted of more than one crime who are incarcerated. It isn't just that one crime. Many times it's a series of crimes. Okay. Other questions for Dale, Commissioner Baker, or Monica? Thank you very much. I think it's a good time to take a short break, maybe 15 minutes, and come back hearing from Vincent Aluzzi and Judge Grierson and anyone else that I missed on the list. So if we can come back at 10:15, would that work? Peggy, thank you.
Yep.
You're bracing for a snowstorm up there?
We are. Be glad to get it too.
Yeah, your neighborhood will
Yeah.
supposed to get up to what, 12 inches?
Hard to believe we will, but
Yeah, I was looking at the map that they drew. It's trying to find the different communities. It
yeah.
looked like the eastern part of the state was going to get hit harder than we over here in the western side. That you were on the slopes that
Yeah.
for tonight and tomorrow morning.
Yeah, I hope we do.
Yeah, it looks like a pretty good storm coming at us.
This is a really big weekend, Martin Luther King.
Yeah,
Big money for
we
the
have absolutely no snow in Bennington. We haven't had for since Christmas, really. We had a dusting, about an inch. I've only been plowed once this winter.
Oh, we had to actually have a bucket loader come
Wow.
after the 44 inches.
Yeah, you got really hammered.
And then
we had 17 here.
And then it all melted within.
We still have about 4 inches on the ground.
We still have snow on the ground.
Our
too.
yard has
Yeah, we do.
Oranges?
about 4 inches, yeah.
Oh, 4 inches. I thought you said oranges.
Or we have 4 oranges.
Oh, you're down south, way south, down at the Aluzi compound down in Fort Myers.
Is that where you are, Vince?
Naples.
Oh, really? Oh,
Naples.
Yeah.
For
Are
the
you
one,
there now, Vince? Or are you up?
No, I'm in Derby, Vermont. My son is in Naples, and I know Randy Brock's got a place there, and I don't know. I presume he's up here, obviously, but his wife may be down there. It's a part of the state that has not been hit hard by COVID. Most of the problems in Florida are on the East Coast, from what I've read.
Oh,
So my son went down because he's doing all his college stuff online, so he could actually be anywhere in the world where there's good internet coverage.
yeah.
good.
Is that where Brian Collmore has his place too?
I don't think it's
I think
Naples.
Brian's on the east, isn't he?
Yeah, it's not Naples.
The thing is, there are college kids all over the world doing things like that. There were 4 young guys here in Ludlow renting a place for 2 months who go to the University of Beijing. And of course, they weren't allowed to return to China, and they're from all over this country. So they got together and they rented a place here for 2 months, and they're moving farther south as the weather has changed. So they're 4 different places. They arranged all this. Of course, they're all computer. Well, everybody is now, people in college, but I mean, they're taking some kind of computer science thing anyway. So, but it was kind of interesting to say, gee, they're here. And of course, they did all their stuff at night. So it was quite interesting to have them here.
Right, it's a 12-hour difference.
Yeah.
Senator White, is your committee taking up the streamlining of law enforcement, or is this committee?
No, we are. We've been working on this for years. In fact, I think when Joe was on the committee, we had a bill to create the agency.
I have one question. Vince worked on this, and this is why I'm asking it now before we get started formally. I realize
We are live though,
it's
remember?
on YouTube. There are a group of enforcement officers in the Agency of Natural Resources who do not have law enforcement credentials. But they are enforcement officers. And I can remember Vince talking to us years ago about those officers moving and receiving the ability to carry firearms, etc. Are they included in it, or is it just the game wardens? Remember what I'm talking about, Vince?
I do. I think the EO that came out yesterday, it's a phased approach, and I think it starts with DMV, E911, and I think the police academy, and then it phases
Then the game wardens.
Well, I think they're being studied, but I don't think they're in the first wave.
Not
But
that,
It comes up with a number of issues as you look at Act 250. These are you know who I'm talking about, Vince, because you approached me about them. years ago.
Yes, I remember. Yeah, it was like in the mid 90s.
Who,
Yeah.
not the game wardens?
Are they
Who are they?
No, it's the enforcement officers in the Agency of Natural Resources who have to enforce Act 250 rules, enforce
Okay,
dumping of, you know,
right.
name it.
Right. Yeah,
And they,
they have an investigative unit or division.
right,
But they're not law enforcement officers.
No, they're not.
currently they're not, but there is, Vince, the reason I'm raising it is because now that we're looking at phasing in all law enforcement into one agency, should they have some law enforcement powers, since they are asked to deal with some pretty tricky situations. And Vince, you remember the issue, and I know
Yes.
you and I discussed it
Oh, yeah.
years ago. I think you were in the legislature at the time.
Right. Yeah, I was.
You were chairing economic development.
They've never come to us, all the years that we've been dealing with law
Well,
enforcement.
that's because they're afraid of you.
I mean, they don't carry firearms.
No,
They don't now, but the discussion was, should they be able to have full law enforcement powers? Just
then
like
they'd have to go through the academy, the entire,
Right.
You're being struck for this.
no, it's, well, but they've never come to us. So we've never, I mean, we've been dealing with this issue for about 5 years and never, ever heard from any of them. We have
I
heard,
think that's your invitation, Vince.
I'll get the word out on the street.
yeah,
I mean, how is that so different from investigators for, say, DCF? In terms of they go out and investigate situations, that's what these people do also, who are working with like A&R, not wardens of any sort, but just the people who go out and see, did they comply with Act 250? I mean, if you're thinking of them, wouldn't we also be thinking of DCF investigators?
Well, they never came and asked me.
No,
I think there's a difference in what they're investigating and if they're investigating civil or if they're investigating criminal.
well,
There's,
DCF is starting out, which might be criminal in many cases, but what is someone seeking to have them included?
no,
Vince was.
Oh,
Well, this is, I mean, it's larger in that, wasn't there a move by VSEA to have us consider parole officers and others to carry firearms?
But
Yeah, that's on our agenda again this year as one of our priorities, defensive weapons for the field officers.
Well, what I would suggest is this is larger than any of these individual buckets. It's kind of looking at should more people, more government agents be outfitted with firearms? And
Actually, I think you've mistaken me.
okay, it seems that way to me. We're
There-
talking about
No,
a couple of
look,
different buckets of people who didn't used to carry them.
so Philip, you
it's
are
beyond the carrying the firearms. It's should they be able to enforce those laws. And the issue with Slate Ridge right now that's come up several times is that the agency investigators do not feel that they are able to do the investigation. The Attorney General and the Department of Public Safety said they can't provide support to these investigators.
I really don't understand that. I would like to have a hearing just on Slate Ridge because I feel as though the administration is continually professing impotence in terms of how they would handle them. But there are laws on the books that it seems to me would be pretty straightforward to investigate and apply, other than that they don't want to do it.
I thought they said they didn't have anything that they could charge them with, and what's going on now is a zoning violation.
Well,
No,
there's
it's
that
not.
Act 250, and then the neighbors are reporting persistent threats and stalking, explosives on the property. So, it's hard to believe that you can't stop your neighbors from threatening you and blowing up bombs on their property.
But what led me to this was the idea that the Agency of Natural Resources investigators do not have law enforcement authority. That was the issue that Vince approached me about 6 or 7 years ago when I was raising. But all right, well, let's get back to earned time off, whatever we want to call it at some point. And our next witness is Vincent Paluzzi, I believe representing the VSEA and not the state's attorneys.
Well, thank you. Welcome back, everyone. One of my successors here in Essex Orleans is a new member of the Senate, and I can't imagine how a freshman legislator, or frankly, any person just starting out as a lobbyist or as even a staff person, just any interaction, it's so hard without developing the relationships and get a sort of the feel and flow of the building. So I'm pleased that the committee remains unchanged with you folks, and I'm glad to be here. As far as good time, before I left the legislature, corrections was overseen by Senate institutions. And in 2000, we passed a good time bill, supported in part by former Governor Dean, because of the inability of folks to know what would be the effect of a sentence. And so that was kind of a line in the sand in 2000, and it's been 20 years since then, and the rules have changed a number of times. At that time, there was a real shortage in corrections, so the department would loosely use the furlough process, and there was a lot of pushback, public pushback, and that's why that statute was passed. In preparation for today, our VSCA organizers reached out to members of our organization, and we represent among all the corrections staff. We also have within the Department of Corrections victim service specialists who are victim advocates, if you will, except they deal with, once the case has been handed over to the Department of Corrections. And the most comprehensive response was really a response about the general uncertainty that the legislation created when it was enacted. And I know that the purpose of the bill is not to revisit the entire question, but rather to fine tune it and make modifications that you feel are necessary. And so I just wanted to suggest that there are a lot of lists that have been created over the years. I think the first list when I was there that was created was the listed crimes bill, which highlighted some of the offenses which were considered either the most egregious or the most violent. And in looking at this draft legislation, it's a unique list, and I may have missed, a prior summer meeting in which, 1 through 8 were put together. So the input I would have to kind of give some finality to individuals who are interacting with the system would be, one, to suggest that there be, to the extent you can do so, a reference to existing offenses which have been identified by the legislature as being particularly egregious, or ones that stand out from the others, like the listed crimes legislation that was passed, I think, back in the late 90s or early 2000s. And that's a thought. The other thought is, it's like when you give a speech someplace and you want to recognize all the individuals who have either participated in some activity which is being recognized or honored, and you always worry about leaving out the one person who played a key role and deserves recognition. And as you structure the bill, in addition to considering some of the lists that the legislature has already included particular crimes or offenses, another thought would be to take a look at the Title 13 and look at the chapters and subchapters which break down the offenses. For example, there are a number of offenses here which there's certain categories of homicide. There's one particular offense for their sexual assault and aggravated sexual assault. But as you look at there are a number of other offenses which by omission, without being listed, perhaps should be considered. And for example, if you look at sexual assault, it's chapter 72 of Title 13, and then there's human trafficking. There are a number of offenses which the state, through its criminal justice system, has identified as particularly egregious offenses against other persons. So that might be a thought as far as how the bill is structured, because if you look through the chapters, there are certain categories, and then of course in those categories you may wish to make exceptions, but nonetheless, just a thought there. Over the last several years, the workload for our members who work at the Department of Corrections has increased dramatically, and you know from perhaps other committees that there are a number of vacancies. There's mandatory overtime. There is, the COVID impact with, I think last week there were 4 facilities on lockdown. And I think one rule should be to make the legislation automatic. Once you come to terms with which offenses apply and receive good time versus those who don't, it has to be a statutory credit, because the staff is overwhelmed with all of the duties and tasks that they have within the system. I know as a state's attorney that these days, I would say in 95 to 98% of the cases that are resolved, the goal is to ensure that the sentence, if it's a 2-serve sentence, includes sufficient time for completing programs that are offered in the facilities as opposed to out in the community. And sentences often are structured after conferring with the DOC sentence computation unit. And the goal always is to ensure that the sentence imposed is one which will enable programming to be completed and give the department sufficient leeway to address those who do not complete those sentences. And so it would be a good idea to, the extent it already has not been done, to build in some provision that allows programming contemplated by the sentences to be completed before the good time legislation would result in the release of a particular individual. Again, most sentences these days, even though they are do include a punitive component, the punitive component often tracks the necessary time that it will take for a person to successfully complete programs offered inside the facility. So overall, those are the suggestions that I have in light of the draft. And we did not have a chance to hear from a lot of folks, but the ones who did respond, in particular, the victim services specialist who sent a relatively long email, did bring up the concern that folks really need to know what the plan for in their lives when someone is sentenced, particularly in crimes in which there are victims. So that's pretty much all I have today.
Thank you. Other questions for Mr. Aluzzi? Senator White.
In terms of making it less complicated for forest staff and easing the burden on them, wouldn't it be less complicated and more straightforward if everybody was eligible and then the determination was made at the time of just like parole or furlough, that they would be released unless there were circumstances? I mean, wouldn't, instead of having many different categories, wouldn't that make it easier on the staff?
Well, there was suggestion about litigation. You know, the commissioner said that the department is often involved in litigation, and unless it's an automatic statutory triggering of when the good time kicks in, it then requires some discretion on the part of the department. And we have a large DOC contingent that we represent. And one of the recurring themes is that it's simply a overwhelming task to comply with all the different dictates and mandates. Not that they object to them philosophically, but from a logistical standpoint, it has to be by rote, more or less. And to do otherwise, they feel is simply just going to set the department back further and, cause more turnover, because they will be viewed as not meeting the expectations of the department, which is attempting to meet the expectations of the statute. So it's difficult at this level, without looking at a final version of the bill, to offer any more thoughts. I'm kind of presenting themes to keep in mind as you craft subsequent iterations of this legislation.
I guess, can I follow up on that?
Yeah, sure.
I guess one of the things that we heard was that that we're trying to do more things individually as opposed to doing them just by rote and by having one rule apply to everybody. And I just wondered about one of the things that Falco said was that having different systems will create disparity among the prisoners. And if that's the case, will that not increase the the complexity for the people who are working with the population, because you're going to have some people who are eligible, some people who aren't eligible, some people are getting, some people aren't getting. And I just wondered about that.
Well, the only thought I have there is perhaps refocusing on my comment that a lot of the sentences, with the exception of the more serious offenses, the listed crimes, if you will, homicide and sexual assaults and kidnapping and the more serious lewd and lascivious cases, by and large, I'd say, Senator Benning's in the same business. I would say that by and large, sentences are structured with programming needs in mind. So the minimum is sufficiently long so that if the person is expected to complete a rehabilitative program while incarcerated, the minimum sentence is tailored to ensure that that sentence will be done. If you, for example, make this retroactive, that may have an adverse impact on the goal that, in most cases are resolved by plea agreement. That would have sort of an unintended consequence on sentences which were agreed to by all parties, including the court. And now you automatically apply good time. And so the person may be 3/4 or 2/3 of the way through a rehabilitative program and they're released as a matter of law. So that's a consideration as you look retroactively, if you look retroactively, make the law retroactive. So I guess I'd have to give more thought about how to structure it, but those are just some concerns.
I might have misunderstood, but I thought when Monica was talking about it, she said that it wouldn't necessarily be automatic, because when they come up for the release, it's going to depend on whether they've had serious infractions and whether they've completed their programming. I think that's what it's called, programming, so that it isn't just automatic, that those other things will be taken into consideration.
Well, looking at the bill as I did, it was not adjudicated of a major disciplinary violation, not reincarcerated from the community. And maybe it's embedded in the rule, which I have not seen. But if it's addressed, then that's, I guess, one less consideration. But just suggesting to the committee to take a look at that.
Okay. Other questions for Mr. Aluzzi? Thanks, Vince, very much. We'll now go to Judge Grierson.
Good morning, everybody.
Good morning, Judge.
For the record, Brian Grierson, Chief Superior Judge, and thank the committee for inviting me to comment on this bill. I was struck as I was listening to the testimony from the various witnesses this morning. No matter what perspective they came from, you were hearing some common terms: inconsistency, disparity. And as I look at this bill, and I want to make sure I understand it in its present form, beginning with Section 818, everyone was eligible for good time. This bill then, in paragraph 5, carves out certain offenses that are later listed in the bill as to be that are the folks that are presently serving sentences of those offenses would be disqualified from any further good time. But then Section 6 allows individuals who are charged and convicted of those same offenses may become eligible for good time, depending on how the court views that. So that creates at least one layer of disparity between individuals convicted of the same offense. I think the more, and I've been trying to get some input from more judges as I was preparing for this today. The concern is, and you've all heard from as part of the justice reinvestment sessions, that about 98 99% of the cases are resolved through plea agreements. And so you have to ask yourselves, as you look at Section 6, what is that going to do to plea agreements? And that will certainly vary from county to county, which I think adds another layer of inconsistency. In other words, someone may reach a plea agreement that is a conditional plea agreement. And I'm sure Senator Benning and others who are practicing in the courts have experience with those. That, in other words, the state's attorney and defense attorney agree to a certain sentence that they want the court to accept, but it's conditional, perhaps from the state's attorney's perspective or the defense, on how the court rules on good time. So you actually go through a hearing on this one, perhaps on this one issue. And the only criteria, as I read Section 6, is balance of in the interests of justice and public safety. And so in effect, it appears to me that the way it's presently structured is you are looking at creating the possibility of more inconsistency among sentencing for similar types of offenses. Now, I will say that every case, no matter if it's the same type of offense, the sentence is individual. And it's wrong to compare one sentence to another of a similar offense, because there could be any number of factors that influence the judge's ultimate decision. But there's a big difference between a contested hearing, a sentencing hearing, and a plea agreement or uncontested sentencing. But this would seem to then open the door for more contested sentencing over this issue and conditional sentencing. The paragraph 6 also talks about if the defendant petitions for this. I cannot imagine any defendant, whether you narrow this list or expand this list, every defendant will file that petition. And if not, that would probably create an issue down the road for ineffective assistance of counsel. So you can anticipate that for every offense on this list, the defendant will petition for good time. And depending on how the plea agreement is structured, it may come in as a conditional agreement. But I can see between states' attorneys, between counties, and between individual judges, we hear repeatedly, particularly in this committee and House Judiciary, about the inconsistency among counties and sentencing. The way this is structured, it seems to just lend further argument to that. And ultimately, you're asking the court, the judiciary, to be the arbiter of whether or not an individual is eligible for good time. That eligibility and how they qualify for it would seem to me to be more of an administrative decision, a decision for the legislature. You're leaving it then up to an individual judge on a given day under given circumstances to determine whether this person is eligible for good time over a sentence that they may be facing of anywhere from 10, 20, whatever. We're talking most serious offenses. So we're talking about a decision that's made on that particular day that's going to impact that individual, obviously, for whatever time they're in the facility. And then the question also comes into play is, what if they agreed to the underlying sentence, but the court's ruling on good time? Are they entitled to appeal that at that point in the process? So some other witnesses talked about litigation. This could create that additional litigation. I think in an attempt to create perhaps more consistency, I think the bill, at least in its present form, seems to do the opposite from the judiciary's perspective. It opens up a lot of doors that are not there now.
I think you're pretty clear, and whether I like it or don't like it, you're clear, and that's hopeful. I think the particular concern that I heard from victims was not about somebody that's sentenced July 1 of 2022, but somebody who was sentenced July 1 of 2018 for a rather heinous crime, and is now, after all of that process that the victims went through, some victims feel re-victimized by the fact that this individual is now eligible to get time off of his sentence or her sentence between now and whenever that minimum comes up. That's what I'm hearing as the egregious problem.
Because of the sentences that have already been imposed.
Right. So I did not hear, although I might now, but I didn't really hear about somebody who in the future might be sentenced for one of these crimes, because by then you will know what the rules of the game are. Do you have any reaction to that?
Well, I guess, Senator, I have to go back and look at some of my notes from the previous hearings.
Yeah.
I understood that, and I know this goes back a while, so I'm not prepared for it today.
It was actually September, I think, but.
Well, my memory is really faded with COVID. I was under the impression that this particular bill, I thought I was in hearings where I understood the victims' advocates were supporting the bill in its then form. And so I've had to look back at now what is proposed in this legislation. I understand that issue, and maybe revisiting that issue as opposed to going forward. You could leave the good time in place for the offenses going forward, but then the issue really is, what do you do with these 8 or 10 offenses of people that had already been convicted? And that may be the appropriate focus for this bill. But I would have to give that part of it more thought. My concern, I don't want to say my concern, the issue that the judges were responding to was Section 6, which is talking about going forward. And so
creating a new
yes
process
yes
within the hearing about whether or not the person should be eligible for good time, and that jump with all the other decisions that the judge has to make in accepting the plea agreement.
So setting aside that Section 6, which is going forward, I understand the committee's real struggle is with what do we do with this population that had already been sentenced under existing rules, and then the good time provision came into effect. I will revisit that issue, and I'm glad to offer any.
Well, I think during the markup of the bill, certainly that would be one of the issues that we would explore. I mean, I haven't heard from all the victims yet, and I think that we're next week or the week after, we're going to try to hear from some of the folks who either are victims or family members were murdered as part in how they feel about the way this new law has been thrust upon them.
And I understand ultimately, even with Section 6, it's a policy decision on the part of the legislature. So we're not advocating pork on one or another, as opposed to.
No, I understand that.
Right.
But I think that the judges raised an important consideration is now you're adding a new element to the sentencing.
Right.
And how we look at somebody next July versus how we might look at them 10 years later. As I think Senator White said, people do change.
So I'll be glad to answer any questions committee members may have, but that's.
Are there questions for Judge Gerson? Thank you, Judge.
Thank you.
Committee, this is time to, we are going to continue our testimony on this issue But keep in mind, as we talk about probation, next Thursday, we're going to get a report from the Justice Center folks regarding their work on Justice Reinvestment 2, and specifically the probation sections. And Senator Nitker and I will be introducing a bill on probation that will be a little different than just credit. But you'll hear more of that during that discussion. And I'm sorry to have held Joe off on this for the week, but I appreciate his patience and waiting until Thursday. So I think once you hear the report, there'll be a better understanding. And
love to see your proposal, and if you're looking for co-sponsors, I may join you.
Okay, well, Bryn has that, and Eric, if you could let Bryn know that would be helpful.
Yeah.
Anyone's welcome to join in on the bill. We'll talk about it on Thursday. I don't think it'll be introduced until after Thursday. But we're going to, as I said, I may not be here Tuesday morning I may be in for part of the meeting. They said to hold 90 minutes for this meeting with the person, so I'll do that. And I believe we're taking up the competency issue, which we have several witnesses scheduled on that. And Peggy's done a terrific job, as usual, on putting together an agenda for next week. I was surprised that the marijuana bill came here, frankly, and I'm glad to have Senator White pick apart parts of that and take it into her committee. But we will be taking that up sometime the week of the 25th of January. So,
We are, Michelle is coming in, I believe, on Tuesday to talk about the opt-in, opt-out section. And I don't know what other things in there that she thinks we should look at as opposed to judiciary.
You're talking about S25?
yes.
I'm still trying to figure out how I ended up as the lead sponsor of that.
Because your name is Benning and my name is Sears and Pearson's name is Pearson and White's name is White. And Michelle said, how should I do this? And I said, just do it alphabetically.
Don't fight it, Joe.
I guess I should flag that for future purposes.
Maybe in the future you want to do it by reverse alphabetical order. That would have made White the prime sponsor.
Yeah. You know, needless to say, I'm receiving some interesting flack from the right.
I'm sure you are. But you're able.
I have thick skin and a thick skull.
Yes. So
You also have a Harley.
Yep.
Can I change the subject here just a little bit?
Absolutely.
I see Commissioner Baker isn't with us anymore, but we took.
Could you rephrase that, please? He's no longer online.
He's no longer on. He's no longer in the committee.
Right.
Yes.
Thank you.
Thank you. But on Wednesday, our committee wrote a letter to, as a committee, we all signed on to it, wrote a note to the administration and to Mike Smith, asking them to put the corrections facilities, both the inmates and the staff, higher on the list of priorities for vaccines.
Which committee did that?
Government operations.
Okay.
Because
we
don't
have scheduled for next Friday the same issue.
Oh,
So,
okay.
Well, I think it's good if they hear it from two separate committees.
I guess that's fine, but yeah.
Well, we just did it because
we were supposed to hear from the deputy secretary or deputy commissioner or whatever today, but she was not available today, but has agreed to meet with us next Friday to go over the issue of those prisoners as well as prison staff, as well as judicial. And maybe we should change that term, Peggy, on the agenda. It's really the judicial staff and others who are in the judicial system. And I don't, maybe Eric can help you with how that should look.
Yep.
But
And
I-
we didn't deal with that judiciary system at all, just, ours was just around.
Yeah, but if the issue was, how do you get back to handling?
Mhm.
And I think Joe raised the issue, until there's vaccination for the judges, the court reporters, the lawyers, the et cetera. How do you get back into holding jury trials? So Friday, we have civil trials that we're going to talk about, and the impact of the delay on those, as well as the judicial and the rollout of the vaccination. I'm getting a lot of calls about the vaccination. Don't know about the rest of you.
Yeah.
Calls and emails about vaccination rollout.
Just from teachers.
Well, I'm hearing it from citizens who are concerned that they're not getting the information, and they see what New York is doing, what Florida is doing, and what other states.
The governor is on at 11 with a press conference talking about the next round of vaccinations.
Well, since it's 10:59 a.m., and unless there's somebody else who has a comment, maybe we should adjourn and go to the governor.
We could listen in for half an hour until the floor.
Yeah, I've got some work to do outside for 15 to 20 minutes just to get some air.
And some exercise in my legs.